the absence of chairing. And that being said, we'll address it no more. And now I'm pleased to first recognize Mr. Michael Conley, Deputy Solicitor for the Securities Exchange Commission. Mr. Conley.
Chairman Kanjorski, Ranking Member Garrett, and members of the subcommittee, thank you for the opportunity to appear before you today on behalf of the Securities and Exchange Commission. My name is Michael Conley, and I am the SEC's Deputy Solicitor. There are a number of issues being discussed here today, but I wish to focus my limited time on explaining the Commission's views regarding the SIPA liquidation of Bernard Madoff's securities firm. We at the SEC are keenly aware of the devastating losses incurred by the thousands of investors who entrusted their money to Madoff. Many, if not most, of his victims have had their lives upended. At the SEC, Chairman Shapiro has urged all of us to learn from that experience and reform the way we operate. Over the past year, we've taken significant steps in that regard, reinvigorating the Enforcement Division, enhancing our inspections, bolstering our training program, revamping our tips and complaints process, and hiring personnel with new skill sets. And we will continue to reform. With regard to the Madoff liquidation, the Commission and its staff have been analyzing SIPA, its legislative history, and case law to determine how to properly value the claims of the investors. While claims for losses suffered by investors are determined under SIPA, the statute does not expressly address how to address the net equity in a customer's account when a broker-dealer has engaged in the sort of fraudulent scheme Madoff perpetrated. As a result, the Bankruptcy Court will soon hear arguments on the various theories proposed for valuing customer claims. In the end, the Court will decide how the investor's claims should be valued. The Madoff liquidation raises a new question. Specifically, how does SIPA apply when a customer's brokerage statements show non-existent positions in real securities that the broker concocted after the fact to support predetermined fictional investment returns? Two primary approaches have been proposed. The first is known as the final account statement method. Under this method, the net equity in customer accounts would be based on the securities positions shown on the final account statements customers received before the firm was placed in liquidation. The second principal approach is the cash-in, cash-out method. Under this approach, net equity is determined by crediting the amount of cash the customer deposited in the account and subtracting any amounts withdrawn from the account. Based on our analysis, the Commission will recommend to the Bankruptcy Court that customer claims in this case should be determined through the cash-in, cash-out method advocated by the trustee and SIPC. However, we believe that the amount should be adjusted to constant dollars to ensure that investors' claims in this long-running scheme are valued most accurately and fairly. The Commission decided not to recommend the final account statement method on the facts of this case because it believed it would result in claims based on account balances that Madoff himself concocted and that bore no relation to reality. Madoff essentially promised customers that he would pick winning stocks for them, did not tell them which stocks he would purchase, waited to see which stocks did well, and then falsely reported that he selected stocks that met their investment expectations. Through no fault of investors, the account statements Madoff sent were illegitimate tallies of a fraudulent scheme. Neither SIPA nor any of the cases interpreting it can be read to support an approach that would value claims based on the fictitious investment returns of such a scheme. As a result, the Commission has concluded that the fairest and most reasonable way to measure the value of the Madoff customers' net equity is to look to the money those customers invested with Madoff as a proxy for the unspecified investments in securities Madoff told them he would make for their accounts. To do otherwise would have the effect of favoring early investors, many of whom withdrew all or more than the principal they invested with Madoff, over later investors, some of whom will not receive a distribution equal even to their principal. At the same time, the Commission is sensitive to fairness concerns raised by the cash-in, cash-out method. That method favors later customers at the expense of earlier customers by treating a dollar invested in 1987 as having the same value as a dollar invested in 2007. In our view, it is appropriate to convert the dollars invested into constant dollars. We believe that approach, rooted in the economic concept of time value of money, will result in greater fairness across different generations of Madoff investors, in effect treating early and later investors alike in terms of the real economic value of their investments. The Commission understands that the total pool of money available to distribute claimants is limited, and that there will not be enough to compensate all victims. That means that money allocated to one Madoff victim will affect the amount of money available to compensate other victims. The Bankruptcy Court's task, and the Commission's goal in making its recommendation, is to arrive at the fairest way, consistent with the law, of dividing that limited pool. I thank you again for the opportunity to appear before you today, and would be pleased to answer any questions you may have.